Welcome back. In this portion of the video, we shall have a small look at settlements. Settlements are the way we effect payment for a compliant presentation under documentary credit. This will be the penultimate part of the series on this video, and we may have one analysis of the various ICC rules applicable to a documentary credit end to end, which will be the last portion. As a preparatory course for CDCs, a crime refresher or a fast refresher, something to serve as a revision for sitting for CDCs exam. Settlement is due when there are complying documents. If there is a complying presentation, the moment the bank examines and decides it's complying, then the settlement process gets triggered. Now, there is a defined and agreed role for an issuing bank, for a nominated bank, or a confirming bank. The defined and agreed role is that when a presentation is found complying, the issuing bank has to pay. The words used by ICC is must honor. The nominated bank must honor or negotiate. The confirming bank must honor or negotiate when a complying presentation is presented to them. And this is due when they find the presentation is complying. So the delivery of documents or control over the goods is decided or is impacted by the conformance of the presentation. If the presentation is not complying, then the documents might not get delivered to the applicant, and in turn the control of the goods remains with the beneficiary and will not pass on to the applicant, and so he will not be able to take the goods. Likewise, or at the same time, the beneficiary is also not able to get his payment if the documents are not in conformance with the requirement of the terms and credit. If complying, or if the documents are discrepant and such discrepancies are waived, then promptly settlement should be made to the presenter by the examiner, that is the nominated bank. And it depends upon the availability, that is available by payment, available by deferred payment, available by negotiation, or by acceptance. In case of deferred payment and acceptance, they will have to accept or undertake to pay on a deferred date and then pay at maturity. So this will be done by the nominated bank, and this has to be done by the issuing bank or the confirming bank when the presentation reaches them and they find it is compliant. So if the documents are compliant, or if there are discrepancies and it has been waived, then it has to be immediately honored, promptly honored. Now, if the documents are present to the nominated bank or a confirming bank, the nominated bank may or may not accept the issuing bank's acceptance of discrepancies when they find the documents are discrepant. Likewise, the issuing bank may or may not accept the waiver of discrepancies by the applicant. So this is their choice and there is nothing much to do. If the nominated bank fails to accept the issuing bank's acceptance of discrepancies, then possibly the beneficiary will have to approach the issuing bank for reimbursement. Article 15 talks about if presentation is made for a complying to the nominated bank or a confirming bank or an issuing bank, and if it is compliant, then the nominated bank or commercial bank will be reimbursed as per the documentary credit terms by the issuing bank. So this is a protection made available to the nominated bank, and it is an inducement for the nominated bank to act as per the nomination. So to prevent a nominated bank from having any sort of apprehensions regarding their capability to get reimbursed in case they part with funds, or in case they undertake a deferred payment undertaking, or in case they make an acceptance, there is an additional undertaking under a credit under the UCP, in addition to the undertaking of the issuing bank towards the beneficiary, that in case there is a complying presentation, then the beneficiary can receive settlement from the nominated bank, and the nominated bank or the commercial bank will be reimbursed by the issuing bank. Then issuing bank will seek reimbursement from the applicant for such a complying presentation. Now, this complying presentation is this is an outcome of the standard of examination of documents as per Article 14. If it is found complying, then what will happen is applicant will have to reimburse the issuing bank. Issuing bank will have to reimburse the nominated bank or the confirming bank, and present payment of proceeds to the beneficiary is due from the nominated bank, and in case the nominated bank fails or not willing to act as per the nomination, then from the confirming bank. If there is no such confirming bank, issuing bank will have to, shall, and must reimburse the beneficiary for any presentation that is complying. Now, what does Article 16 talk about? Article 16 talks about a situation when documents are not complying, when there are discrepancies, when it is decided that it will be refused and rejected and not taken up. So, if the documents are compliant at the nominated bank but not at a confirming bank counters, the situations where the documents are not complying in any of the bank counters is that the beneficiary will never get a payment. But there could be conflicts, or there could be situations which lead to some inconsistencies when it is complying in one end and not in another. What is it? If the documents are compliant at the nominated bank when the beneficiary presented, but not at the confirming bank when the nominated bank presented to the confirming bank for reimbursement, then the confirming bank need not reimburse the nominated bank. Why? Because the documents are not complying in the counters of confirming bank, and so the confirmation is no more valid. But the nominated bank may recover from the beneficiary whatever payment they have made. Why? Because most of the time they would have made it on recourse basis, and this recourse basis depends upon the nomination agreement or the willingness to act as per the nomination and the terms associated with it that has been agreed between the nominated bank and beneficiary, if any. That is why we use the word if payment was on recourse basis, then the nominated bank may be able to recover from the beneficiary. We are not saying can, and we are not saying payment was made on recourse basis. Now, if the documents are compliant at nominated bank but not at issuing bank counters, here it is not at confirming bank counters, here not complying at issuing bank counters, issuing bank need not reimburse the nominated bank. Issuing bank will not pay. Why we are saying need not reimburse? Because maybe the issuing bank is not willing to accept the applicant's waiver, and so the issuing bank's undertaking is not reinstated, and so issuing bank is not reimbursing. The other alternative is issuing bank may approach the applicant may accept the discrepancies, issuing bank may also accept those discrepancies, then issuing bank may reimburse the nominated bank, though it is discrepant. Issuing bank may seek refund of claim paid to the nominated bank by the reimbursing bank or the issuing bank. Now, what will happen is when the documents are presented, suppose it's available by site transaction, and then the nominated bank will immediately claim payment either by lodging a reimbursement claim to the reimbursing bank, or may send a message to the issuing bank saying documents are compliant, we are taking up, please cover us. And then immediately the issuing bank would have paid, because as per the DC terms, if it is a site payment, payment is due immediately. And in such cases, if the issuing bank is already out of funds in some form, either from their own account or from reimbursing bank account, then if they find the documents are non-complying, issuing bank may ask the nominated bank to refund the money. The practice is that most of the time the issuing bank will not ask for refund, because once the issuing bank raises these discrepancies with the applicant may accept and waive those discrepancies, or the applicant and beneficiary may get into an undertaking that okay, in spite of the fact that discrepancies are there, for some reason the documents are being taken up, or the applicant may be waiting for the goods and goods are already incurring demurrage and there is no further time available for further negotiation, and so they are willing to take up the discrepancies, whatever be the reason. And then ultimately in a week or 10 days time, it will all be agreed by all the parties that payment is due. In such a case, calling for a refund and then making another remittance is a cumbersome process and involves additional banking cost in the nostro centers, and so issuing bank may not ask for a refund, but issuing bank may seek. They have a right to do so. The nominated bank may be able to recover the funds paid to the beneficiary under discrepant documents if payment was on recourse basis. Now, this is where the question of documentary risk comes. Now, if the nominated bank is acting as per nomination, they are examining the documents and they are finding it compliant, and then they are paying. Then, if there is non-payment is because of the documentary risk, if non-payment is because of the discrepancies in the documents submitted, then the nominated bank should technically not be recovering from the beneficiary, because they undertook to act as per nomination. They charged a nomination negotiation fee or whatever it is, and then they find that the job they done is not complying with the DC terms. So it depends on whether the payment was made on recourse basis or not. When they agreed to act as per nomination, did they have any other additional agreement with the beneficiary? That is what it matters, and this is why what we call as a documentary risk. The other risk or the bank and country risk, for which we have something called confirmation, where the confirming bank gives a separate undertaking similar to the one of the documentary credit, saying if the DC's terms and conditions are met, if the stipulated documents called for by the documentary credit is submitted, then we as a confirming bank will pay, and our undertaking is in addition to separate and independent from the undertaking of the issuing bank, but dependent on the underlying DC. If documents are complying at a confirming bank but not at the issuing bank counters, then the issuing bank need not reimburse the confirming bank. Just like the issuing bank need not reimburse the nominated bank, issuing bank need not reimburse the confirming bank. And confirming bank cannot recover from the nominated bank. We have earlier seen the nominated bank may recover from beneficiary, but here the confirming bank cannot recover. Why? Whenever a payment is made by the confirming bank, it is without recourse. Whenever a payment is made by the issuing bank, it is without recourse. Confirming bank must pay, issuing bank must pay. It's not may. So once they have paid, that's it. That's the end of the road. The confirming bank cannot cancel a deferred payment undertaking or an acceptance or an agreement to advance funds on a future date. Now, if the confirming bank has made a side payment, they cannot recall it. If the confirming bank had undertaking a deferred payment undertaking or may accepted a draft or documents drawn on them, or maybe they agreed to advance funds on a future date, that is a negotiation. If they have done, then they cannot reverse or cancel or revoke such an act on their part till the maturity date, and on maturity date they will have to honor. They will have to honor the deferred payment undertaking. They will have to honor the draft accepted by effecting payment. Now, confirming bank negotiates without recourse. When our documents are presented to the confirming bank negotiates without recourse. If the documents are directly presented to the confirming bank, if the confirming bank pays the beneficiary, that's the end of the road. And if it is not complying at the issuing bank counters, the confirming bank cannot recover those funds from the beneficiary, in spite of the fact that they are both the nominated and confirming bank, and they have a valid confirmation at the point of presentation, at the time of presentation. If the documents are complying at the issuing bank counters but found discrepant by the applicant, then this is a serious problem, because the LC application, the letter of credit application given by the applicant to the issuing bank requesting and authorizing him to issue a documented credit on their behalf, states that this is subject to UCP and you may issue a letter of credit and you may pay against stipulated documents, provided that terms and conditions are complied as herein and evidence in the document submitted. Now, the applicant need not reimburse the issuing bank because the terms and conditions of the credit had not been complied as per his LC application. So, he need not reimburse the issuing bank. He will seek refund of the amounts if debited already. He will seek refund of the amounts if his account is already debited in case of side payments or in case of any other direct TT reimbursement claims received and paid. The issuing bank cannot recover from the nominated bank, confirming bank, or beneficiary. Why? The issuing bank cannot recover because issuing bank had found it is compliant, and because they found it compliant, what they honor or what they pay is without recourse, and because they must honor a compliant document. Issuing bank honors or pays without recourse. Now, the concept of recourse or without recourse is not discussed by UCP because it's outside the scope of UCP and it's for the local practice and local laws to apply, because the concept comes from or stems from the concepts of negotiable instruments. Now, DC, the documented credit, has to clearly indicate the availability, how it is available, where it is available, when it is available. So, how it is available? Available by acceptance, available by deferred payment, available by side payment, or maybe available by negotiation. Where it is available at the nominated bank counters at a place where the credit expires. When it is available till the date the credit expires, or at best 21 days from the date of shipment, or 14 or 7 days as given in the presentation period. So, confirming documents should be presented within X number of days from the date of transfer document as per the credit, or at best within 21 days from the date of transfer document. In any case, within the validity of the credit, and this should be presented to the nominated bank at the place as per the credit. And then, this is what is availability. The place where it has to be presented, and how the payment is available, and up to what date it can be presented. So, regarding the place, regarding the way in which payment is available, if it is by side payment, if it is confirming bank, they must honor, and their honor is without recourse. If it is a nominated bank, may or may not honor, and generally without recourse. A side payment by a nominated bank is generally without recourse. The nominated bank may enter into a separate undertaking for recourse that is outside the documented credit terms. But the side payment by a nominated bank under a normal complying presentation of a documented credit is without recourse. But they may or may not honor. There is no obligation on their part to honor, but if they honor, it is without recourse if they make a side payment. Confirming bank must honor and issuing bank must honor. Issuing bank and confirming bank honors without recourse. If it is available by deferred payment, then confirming bank must honor by undertaking to pay on a deferred date and then pay on a deferred date. The undertaking as well as the payment is without recourse. Nominated bank may or may not incur a deferred payment undertaking. And if they undertake to pay on a deferred date, they may or may not pay on the due date. And their undertaking as well as their payment on due date is, the payment is without recourse, but the undertaking is they can revoke at a later date for whatever reason. And then the beneficiary will be forced to approach the issuing bank, and the issuing bank or the confirming bank will pay. That's a different issue. The issuing bank, they must honor. They must honor by incurring a deferred payment undertaking and paying at a mature date. Their undertaking as well as payment both are without recourse. Confirming bank, the undertaking as well as payment is without recourse. They cannot cancel or revoke it at a later date, or they cannot recall the funds. But nominated bank, they may or may not incur a deferred undertaking. There is no compulsion. And once they incur, they may or may not pay on the due date for whatever reason. And if they pay on due date, that payment is without recourse, but the deferred payment undertaking is not irrevocable. Here, honor means incurring a deferred payment undertaking and paying at maturity. So when we say issuing bank honors or confirming bank honors, they incur a deferred payment undertaking and then pay at maturity. Their payment is without recourse and their undertaking is without possibility of revocation. If a credit is available by acceptance, then the confirming bank must honor without recourse. Honor means accepting draft or drawn on it and paying at maturity. Nominated bank may or may not accept the draft. And if they pay at maturity, it is without recourse. But if they do not pay at maturity, then nothing will happen to the nominated bank. The beneficiary will have to approach the issuing or confirming bank to say the nominated bank refused to act as per the nomination by accepting a draft but not paying. And then the issuing bank must honor or the confirming bank must honor, provided the presentation is compliant. Issuing bank also honors without recourse. That is, the payment made by the issuing bank cannot be recalled. The draft accepted by the issuing bank cannot be cancelled or revoked. If it is available by negotiation, confirming bank will advance funds. Will advance funds means what? They must negotiate, or they will agree to advance funds, and it is on without recourse basis. Negotiation by confirming bank is without recourse basis. Nominated bank, they may or may not agree to negotiate. That is, they may or may not advance funds or agree to advance funds. And if they agree, it is with recourse or without recourse basis, depends upon how they have agreed with the beneficiary. The negotiation by nominated bank can be with recourse, can be without recourse. But the negotiation by confirming bank is always without recourse. And issuing bank does not negotiate but honors or pays. Why issuing bank does not negotiate? You can negotiate only drafts drawn on another party. Most of the time, the drafts are drawn on the issuing bank. That is why the other two banks, the nominated and confirming bank, is able to negotiate such drafts. The nominated bank might obtain reimbursement by sending a message to the issuing bank claiming reimbursement for a complying presentation. The moment the nominated bank finds the presentation is complying, they may send a message to the issuing bank saying presentation is complying, please cover us. Please allow us to debit your account, please credit our account, please remit as per our instructions, whatever it is. The risk of being out of funds before documents are examined at issuing bank counters is the only risk that issuing bank faces. If it is a side transaction, the issuing bank may have to pay the nominated bank on receipt of this claim, and by the time they pay, they may not be able to receive the original documents at their counters for their examination. So their risk is that it is complying at nominated bank counters but not complying at issuing bank counters. That is the risk for the issuing bank in a side transaction when a reimbursement claim is allowed by telegraphic transfer. There could be situations where there is a mix of settlement terms. This is also another risk. What's a mix of settlement terms? Some portion is payable at site and some portion is payable after a specific tenor. The portion payable at site we will be out of funds by the time the issuing bank examines the document. But the portion payable after a specific tenor, maybe 60 days from site or 60 days from shipment, this portion, if the documents are found non-complying, then the issuing bank might choose not to accept. If there are acknowledged and valid assignment of proceeds, if there is an assignment of proceed letter given by the notice given by the beneficiary, and if the nominated bank, confirming bank, or even issuing bank had taken notice of it and acknowledged the fact that we have received a notice of this assignment of proceeds, then when a proceeds are due, the proceeds may not be payable to beneficiary but may be payable as per the assignment. If there is an evidence of red clause payments, if an advance payment has been made or pre-shipment advance has been made to the beneficiary by any of the banks, a nominated, confirming, or an issuing bank, then out of the proceeds available payable under this complying presentation on hand, a portion might have to be used to offset the red clause payment made. In case of a revocable DC, the nominated bank and the confirming bank will have to check whether any presentation has been received on or before the receipt of revocation notice. In case of issuing bank, they have to check whether the nominated bank or confirming bank had approached them with a notice of receipt of a complying presentation or having taken up a complying presentation and the presentation being forwarded to them. Maybe it is still in transit. And those payments or settlements will have to be made before the revocation of the credit could come into effect. In case of revolving DCs, we have to check whether the installment drawings aspect is applicable or whether it has been explicitly removed as required for a revolving credit to be fully operative, and whether shipments as per Article 32 is applicable or not. And when the credit has to be reinstated based on presentation or based on payment or based on dates, or how the present presentation and their settlement affect the amount available under the revolving DC. Maybe in a revolving credit, there is no installment shipment clause, or that clause, the particular article of the UCP had been explicitly excluded. But maybe there is a partial shipment allowed, and then the letter of credit is for $100,000, and the partial shipment is allowed almost on every day, and $100,000 is for the month. And so there could be some 30 different presentations made, and then the documentary credit might get reinstated at the time of every presentation to ensure the overall amount available is 100 in spite of the settlements made. Or maybe if it is revolving with respect to time, multiple partial shipments could be made on different days, but the documentary credit amount will keep on reducing at the time of every presentation till maybe the 1st of January, 1st of February, 1st of March is arrived, so that on when those dates arrive, or when we encounter completion of a particular period, we will be reinstating the amount available under the credit. What's a transferable DC? Transferable credit is something that has been transferred at the request of the first beneficiary by the transferring bank to the second beneficiary. Now, the documentary credit terms may say presentation will have to be made to the transferring bank. The documentary credit terms, the transfer terms might say the first beneficiary has to reinstate their invoice and draft so as to draw for a higher amount. In case the second beneficiary's documents are directly received by the issuing bank, then we run the risk of first beneficiary not getting paid his portion of the value of the credit. So that has to be taken into account while making settlement by the issuing bank and nominated bank or the transferring bank.